This case is about more than probation violations. It's about family land, accusations of harassment, and a defendant who just can't seem to follow the rules. On one side, we've got a man claiming he just misunderstood probation rules. On the other, prosecutors saying he's breaking conditions left and right while still facing a DWI. And as if that's not enough, there's neighbor drama over inherited property, accusations of illegal hunting, and even cattle running through private land. Stick around, because this case is about to unravel with contradictions, legal tension, and some shocking revelations.
On November 7th, we're having 82 students come.
80 on what day, November 7th?
That's the date they picked. So
That's a Tuesday, if I recall.
Did you catch that? The judge is making small talk about school tours and first graders, right in the middle of a criminal docket. This is classic courtroom reality. Serious cases one moment, light-hearted community talk the next. But don't be fooled by the laughs, because the very next issue is about probation violations and a man's freedom hanging in the balance. That's the whiplash of real court.
it is. So we're either going to be seeing them in the morning or in the afternoon. I'm hoping to just give them a tour of the commissioner's court and have different people from different fields walk in there. Because I don't think people understand we have major criminal cases here.
Yeah.
And they are first graders.
First?
82.
I don't think it's.
And they're coming with 10 chaperones. So what our plan is going to be is
Scare them?
no. There's not going to be the jail tour. But
I mean, the 144 can do that all the time.
no, but what my plan is, yeah, we're going to take them to commissioner court. Hopefully they won't have anything. They can meet commissioners, and then I'm going to do stagger where different people can come in and tell them what they do. And then give them a tour of the Heritage Center, because nobody ever tours that. I went there. That was a great tour.
I went there for the first time last week. Holy cow, that's some cool stuff.
It is. So that's what we're doing. So you'll be a part of the tour as well.
Thanks, Judge.
Look at me just volunteering people.
Yeah.
Mr. Wilson, what is happening? He wants to travel.
Judge, what we're asking for is to travel to Courtroom Springs. The motion says every other week. We have not been able to, or we've just started the process, of obtaining his occupational driver's license. So even if it is just for 1 week in a month, that's fine, Judge. The situation down there is he has land that he has inherited.
Here's the defense's play. They're painting this trip as harmless, just a man trying to maintain inherited land. But probation rules aren't suggestions, they're court-ordered restrictions. You can't just pack up and leave town because it's family property. This is where many defendants stumble. They think personal reasons excuse violations, but in the eyes of the court, any unapproved travel is a breach, plain and simple.
It is family land. And so they're trying to, one, maintain it, but two, also prepare to have it sold.
And where is this located?
Courtroom Springs.
Courtroom Springs, that's in Demet County.
All right, so here's the problem. These are the concerns that I have. Well, that probation has brought to my attention. They're saying that he's already left for Courtroom Springs without permission. So why did that happen, going there without permission?
I told my probation officer that I was going to go down there. I've been trying to sell it, and she said I didn't get permission from you, and that's what happened. But I haven't been back since, and I do apologize. I wasn't trying to do anything I wasn't supposed to for probation.
He was under the belief that telling his probation officer was sufficient.
Okay. And then what is this other issue about this harassment?
So that issue, Judge, is a neighbor. It's actually the neighboring land. And so since our client's grandfather passed away, the neighbor has been found on the land, using some of the land, offering some guided tours or hunts, I suppose.
He's been caught doing leasing hunts and getting paid for it, but it's not his property. And basically what happened is when I inherited, I kicked him off the land, and he's been mad ever since that he can't go hunt there anymore because he's been running cattle down there for 25 years.
Because he's been what?
And here comes the twist, neighbor drama. Imagine inheriting land and suddenly finding out your neighbor's been running hunts, leasing property and making money on land that's not even his. No wonder tensions are high, but legally this raises bigger questions: trespass, property rights, maybe even fraud. So now the defendant isn't just fighting probation restrictions, he's caught in a messy property feud that could add fuel to his case.
He's been running cattle down there. That's how he comes in and out. So he has like access to the ranch, but you know,
So essentially, Judge, they're fighting over the land. This is the issue.
All right, state.
Yeah, Judge, we're opposed. He's still pending a DWI here in Bear County. Conditions of his probation, he's got partial GPS for employment only.
Boom. The prosecutor lays it out like a hammer: a pending DWI, a suspended license, GPS restrictions, and terms he agreed to for 10 years of probation. This is critical. Probation is a deal. The defendant avoids prison, but only by following rules. When prosecutors point out violations, they're basically saying, he signed this contract and now he's breaking it. That's not just risky, it's dangerous for his freedom.
He's got a 2-year Texas driver's license suspension. These are all things that he agreed to in exchange for the 10 years probation. I know you've got the steps in front of you, Judge.
Yes.
I was unable to submit the video. It's a video, so it's not part of the paperwork, but this is a good case for us. And part of the agreement in exchange for the 10 years is these conditions. So we're not inclined to agree to these. It also sounds like he's also getting into trouble, and he's not following probation's instructions. And besides all that, I think it's premature to be granting this while he's still got the DWI pending. It was my understanding, and this is probably less the defendant's fault and more his counsel's fault, but it was my understanding that they were going to.
Notice the defense scrambling here. They're trying to soften the blow, admitting fault but blaming delays and confusion. This is a common tactic: acknowledge mistakes, frame them as misunderstandings, and hope the judge buys it. But judges aren't easily swayed, especially when probation violations pile up next to pending criminal cases. Question for you: if you were the judge, would you give him another chance or lock him down tighter?
Plead to the felony and then go take care of the DWI. And this was a couple months ago that he pled on the evading the vehicle. So I don't know why that's even still pending. But Judge, I would oppose any sort of motion to travel until he's at least taken care of all his Bear County cases.
I agree, honestly. I mean, I didn't mean to travel over there, but I agree with and so let's take care of. I don't have to travel down there, and I'm sorry for going down there.
And that was our intent, Judge, to resolve both cases. I'm not sure if it was a SETI, if we haven't had SETI. I don't know, Judge. I can't speak to the misdemeanor. I've not represented him on that case.
All right, so when is the misdemeanor case set?
So way to get done. I'm sorry.
It's actually this Thursday on the 26th. The reason why it was taking so long is because they haven't got my results back yet.
Okay. All right, probation.
Your Honor, as stated in the supplemental report, Mr. Wilson will be getting the GPS installed today. So that's one thing we have going for us, but I would have to lean on the side of caution in regards to the outstanding case and then the information in regards to the neighboring land, that situation.
All right, so I'm not going to make a decision today.
Probation weighs in, and notice the cautious tone. They aren't flat out condemning him, but they're waving red flags about land disputes and pending charges. Judges listen closely to probation officers. Why? Because they're the boots on the ground, monitoring defendants day to day. If probation says we need to be careful, that's a big deal. It signals to the court that trust in the defendant is shaky.
I need more information. This is the information I need. I want to know what's happening with his harassment. I know it's just an allegation of the resident. And I don't know if there were police reports filed or not, but if they were, I want to see those. I want to see what's happening with the DWI case, because that is a concern for the court. So we have the evading and then the DWI that the state is telling me was supposed to be taken care of.
And I don't want to misrepresent, Judge. I was like, you need to go take care of this. We didn't have an agreement.
It wasn't part of the plea, so I'm not sure why he would
It wasn't part of the,
anticipate counsel
it wasn't part of
taking
the,
care of cases that his
It wasn't part of the plea, but someone
Correction.
from the firm represent, whoever was representing that day, Shannon was like, yeah, we're gonna take care of this right now, which I assume was not gonna be hanging out here for 2 months.
Okay. All right, so that's what I'm gonna want. So I'm not gonna make a ruling on it. And he's not allowed to leave Bear County. Those are the rules.
Okay.
But if you want to reset this, you can. But I want to know what is happening.
Here's the judge's move. No decision today. Instead, more information needed. Smart, cautious, and strategic. Judges often delay rulings when key facts like police reports or pending charges aren't clear. It's not weakness, it's control. The judge keeps the power by saying, I'll decide when I'm ready. And notice the strict boundary. No leaving Bear County. That's the law speaking loud and clear.
With the harassment issue and what is happening with the DWI.
Okay, Judge, I will get that.
And
together
then
for
once
you.
that's done, you all can come back.
Okay, thank you.
Sure.
And Your Honor,
Yes.
just to make sure we close any loopholes in regards to GPS is concerned. Mr. Wilson says that he's currently in school.
Mhm.
I know you said that the GPS was for partial, for work purposes only. Just want to confirm with the court that it's okay for him to do a schooling and as long as they're in
Yes.
the amount of time. Thank you.
Yes, it's okay to do school, but you need to provide proof of that to probation. All right, is there anything else?
I don't think so.
All right,
you,
thank
Judge.
you. You're welcome. Calling 2023 CR 7717, State of Texas versus Deborah Jean Yulan. Can I have the parties announced for the record for the state
Daniel Escobar for the state of Texas.
defense?
Matthew Allen for Miss Yulan.
And are you Deborah Jean Yulan?
And Your Honor,
How do you pronounce your last name?
Yulan.
Yulan. Okay.
New case, new defendant, Deborah Yulan. And this one's a heavy hitter, a felony DWI, third or more offense. That means she's no stranger to these charges. For context, Texas law treats repeat DWIs brutally. We're talking prison time, fines up to $10,000, and years of probation. And yet she's asking for probation again. Will the judge trust her? Or has she run out of chances? Let's find out.
I've been watching too many Korean dramas, so I'm pronouncing it differently now. Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Yulan, I'm showing you what's entitled application for probation. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
Ms. Yulan, I'm going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
I did, Your Honor.
Did you understand your charge while driving while intoxicated, third or more? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Judge, we would be okay with proceeding with sentencing. I just wanted to bring one thing to the court's attention. I know that there's going to be a TAP evaluation. We don't know how that will turn out until after the evaluation.
Mhm.
Ms. Yulan is currently in a voluntary outpatient program. And so depending on what the TAP is, if the court would allow us to reapproach or file a motion if we felt necessary.
Yes.
Okay.
Right. Is there anything else you'd like to say on behalf of your client?
Just that it's my fault. She had emailed me the paperwork. She's done the DWI courses and we'll get those to probation so they can have them. But she has come to a realization again that she needed treatment herself, no matter what was going to happen. She knows it's up to the court whether she even gets probation. She was very grateful for the offer from the state to be able to have that opportunity. But she knew regardless of whether she was going to get probation or not, that she needed to do something to better herself. So she is working at this time.
Here the defense shifts gears, emphasizing rehabilitation, treatment programs, and self-awareness. This isn't about denying the crime. It's about showing the court she's changing. Judges love to see proactive steps, courses, outpatient treatment, counseling. But here's the tension. Is it genuine or just strategy to dodge prison? That's the million-dollar question. And honestly, how many chances should repeat offenders get?
I don't believe she's driving. She has but she does have a device. I don't believe it's had violations while on the device. And so she just asked this court to follow that plea bargaining agreement and give her the opportunity to continue her treatment and hopefully never be back in the Bexar County courthouse again.
All right, what do you do for employment?
I'm a server,
And when you say a server of what?
a waitress.
Okay. So you're not working the bar area?
No.
Do you have any children?
I do.
What are their ages?
5, just one child.
Okay. Live with you?
Not currently,
Currently, who are they living with?
with her father.
Is that because of this? Has Child Protective Services ever been involved?
No.
So how often have you been drinking?
I haven't been drinking since this offense.
All right, so before this, how often were you drinking?
Several times a week.
All right. Do you have a sober coach?
I don't yet. I've heard of them.
All right. So have you been looking?
I will be looking.
So your counsel says you're in outpatient treatment. What outpatient treatment is this?
Alpha Home.
Okay. All right, this is what the court is going to do. Court is going to sentence you to 10 years in the prison, suspended and probated for 8 years. There's a $250 fine that will be probated. The education courses that your attorney said you've done, when were those completed?
I
They were just within
maybe a
the,
month or so ago.
Okay,
yes, sir. I think within a month to 6 weeks.
all right. Probation, if those courses were completed later than 2 months, she's gonna have to redo them. But yes,
And which courses are they?
she's gonna give you documentation of them. What courses have you completed?
I've completed the victim impact panel. I
Alright.
haven't done the intervention course.
All right, she's only done the victim impact panel. So I'm gonna order the victim impact panel, ignition interlock for half the term. Now, with regards to ignition interlock for half the term, that is your agreement, but I get to make the decision whether it's taken off or not. You understand?
Absolutely.
DWI intervention, DWI education course. We'll do the TAP evaluation. She's currently in Alpha Home. So if the TAP evaluation recommends inpatient treatment and she's not had any violation, she's continue with the outpatient treatment with Alpha Home. But if there are some violations, we're going to do something different potentially. You understand?
Yes.
So I'm going to order Alpha Home outpatient treatment. And are they having you do sober meetings?
I don't know what.
Oh, it's NA meetings. They call them
Oh.
sober support meetings now.
Yes, yes.
How often?
Twice a week.
All right, we're going to do sober support meetings
Mhm.
2 times per week until further notice. 120 hours of community service restitution. I'm gonna order parenting classes. Once that's complete, the community service hours will be deemed satisfied.
The sentence is set: probation, classes, community service, ignition interlock, GPS monitoring. This is what's called a structured second chance. She's technically avoiding prison, but her life is now micromanaged by the court. One slip, one missed class, one failed test, and she could be serving 10 years behind bars. Probation isn't freedom, it's prison without walls, and the pressure is enormous.
Are you able to take off from your work for 10 days or no?
I would have to talk to my boss. I don't know.
All right, so what we're gonna do then is we're gonna do 30 days GPS for work and treatment. She'll be allowed to work and she'll be allowed to go for a treatment in lieu of the 10 days at the Bexar County Jail. And the reason why I'm doing that, because I know the Bexar County Jail is overcrowded. I know they have issues. That is the only reason why I'm doing that. Otherwise, you would spend your 10 days at the Bexar County Jail. You understand?
Yes, thank you, Your Honor.
And probation, see if they can waive fees. There should be proof of employment within 30 days. There should be no employment as a home health care provider with minors or any establishment whose sole, I won't say sole, but a majority of their business is through the sale of alcohol. There should be regular reporting by Zoom or in person. Regular random UAs and probation. I think they may test at alcohol. So if you're satisfied with alcohol testing, you can do that. If not, then you don't have to. And we'll do field visits 1 time per month until further notice. Probation, is there anything else she needs?
Yeah, it's just,
I think there should be a Texas driver's license suspension. And that will be for 2 years.
yes, Judge, and she is not driving currently. I think she has a vehicle that's inoperable. So she's been on the mobile device. I
Okay.
don't know if the court would allow her to continue the mobile device.
All right, I'll allow her to continue with the mobile device upon proof that the vehicle is inoperable and an affidavit of non-driving.
Yes, Judge.
All right, is there anything else, probation? Okay. All right, is there anything else that you need from the court to be successful?
Believe so, Your Honor.
We can go off the record. Drinking and driving should not be done whatsoever. And I know that people never go out and drink and expect that they are going to drink and drive and be intoxicated driving. You start drinking, things get out of control. That's why you should always have a designated driver. I don't care if you think you're just having wine. Now you know you're one of those people who are in that group who cannot drink at all.
I am on this.
So here's the thing, what I've discovered, and my statistics professor will be very upset with me because I haven't done the research, but this is what I've noticed. People who get in accidents and they are intoxicated, you know what ends up happening? They end up killing the soccer mom. They end up killing the grandmother who's just minding their own business. And the person who's intoxicated, they just walk away from accidents fine. This could have been so much worse because there's an accident. And state on this case, was there any restitution?
Judge, I'm not aware of any restitution.
Okay, all right. So just so you know,
Okay.
if there's any type of restitution, probation will let me know and we'll have a restitution hearing.
Yes, sir.
So, and you don't want to be the person who's driving and your 5-year-old is in the car with you
Yes.
and you're in an accident and then the 5-year-old ends up injured. That's what happens in these type of cases. Do you understand?
Yes, sir.
All right, good luck to you.
Thank you.
You're welcome. All right, we're going to go on the record in 2023 CR 8695 State of Texas versus Paul Anthony Pettis. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
Your Honor, good morning. Frankie Sandoval on behalf of Mr. Pettis.
Are you Paul Pettis?
Yes, ma'am.
Your attorney has filed a motion to withdraw. Are you aware of that?
Yes, ma'am.
All right, what's the purpose, the reason for withdrawal?
Your Honor, there's a conflict of personalities. Mr. Pettis had communications that haven't been very fruitful and continue to go downhill from there, Judge. And from my conversations with Mr. Pettis and his family, they're attempting to hire an attorney, but the one thing that they are certain of is they do not want me to represent Mr. Pettis.
All right, so Mr. Pettis, this is your attorney until your family hires one. And this case is going to be moving whether you hire an attorney or not. Do you understand?
Yes, ma'am.
All right. So the motion to withdraw is denied.
So, I couldn't get another, attorney?
No, this is your attorney.
Now we get courtroom wisdom. The judge schools the defendant on how plea deals actually work. Many people think defense attorneys can magically force the state to offer better deals. Nope. The state sets the terms, the defense can counter, and the judge oversees. That's it. This breakdown is pure gold. It shows how negotiation really looks inside a courtroom, and it's often way less glamorous than TV dramas make it seem.
Let me explain something to you, and we can go off the record. The way things work, there are attorneys who have been approved to handle certain levels of felony. Your case is a second-degree felony. This attorney has been appointed. You don't get to go forth and say, let me just shop and pick the court-appointed attorney I want. That's not the way it works. You understand?
Yes, ma'am.
Right. This is what I've discovered. I've been a defense attorney. I've been a prosecutor. Clients that I've represented, sometimes they get upset with me. You know what they would get upset with me about? Because I'm not getting the offer that they want the state to make to them. State can make whatever offer they want to. You can think it's ridiculous. I encourage people not to use the term ridiculous because then that's not being kind. So if the state makes you an offer and you don't want to accept it, your attorney will say, this is the offer the state is making. And you can say, I'm not accepting that. And then guess what? He'll go back to the state and he'll say, he's not accepting your offer. Or the state will make an offer and your attorney will tell you that what the offer is. And you will say, you know what? I want to accept that offer, but this is what I will accept, which is called a counter offer. So you are rejecting the offer that the state has made and you're asking for something different. Now, when your attorney goes to the state with your counter offer, if you make one, the state can think in their mind that's ridiculous and say, no, the only offer we're making is what we made to you. That's how it works in here. And you can either accept it or not. You can be upset that you didn't get the offer you wanted. I would have clients, sometimes they would be upset because they want their case dismissed yesterday. We are where we are. So your only choices are the state can make an offer. You can accept it or reject it. You can give them a counter offer or not give them a counter offer. And then if you all can't come up with an agreement, then it'll be set for jury trial. You understand?
Yes, ma'am.
That's the way it works. How old are you?
I'm 18.
All right. So yeah, you need to talk to your attorney. And whatever the state has in their file or whatever discovery, your attorney will go over it with you.
I'll tell you why I wanted to dismiss him.
Sure. If it's going to be something negative about you don't think, okay.
Pettis, SID number 117.
Oh, no. You don't have to read it as though you're reading a legal document. You can just tell me.
Oh, because
what is your issue?
I dismissed him because on my behalf on the grounds that Mr. Sandoval is biased and has been neglectful of his duty under Article 2.03 and has failed to represent me in the way he is supposed to.
All right, so let me just tell you, he's here right now. State, do you have your file down here?
It's here, Your Honor.
Have you read the file?
The defense counsel actually asked me to review it and give an offer.
Okay, so there you go. He's representing you. What do you expect him to do with his representation? What do you specifically want him to do?
What do you mean by that?
I mean, you're saying he's not representing you. What do you want him to do?
Just, how can I say it?
You don't have to speak in legal terms. It's fine. You can just speak to me. Well, let me help you with here. Let me ask you this. Have you asked him or talked to him about what you want him to do or what you feel he isn't doing?
Okay.
All right. So discuss that with him. And I guarantee you, if it's something legally or ethically he's not allowed to do, he will tell you, ethically, I'm not allowed to do that. And if that's the case, then that's the case. but he will talk to you. Mr. Sandoval, do you have any objections to speaking with him?
No, Your Honor, we visited several occasions over Zoom.
Yeah, he will speak to you. So you're here, he's here, you can speak to him. All right. Ms. Ferguson, on this case, can I have a 30-day reset, please?
I can do November 28th.
All right, we're going to come back on November 28th. If you all work out something differently, your attorney can request it and we'll see you sooner than that. You understand?
Yes, ma'am.
All right, thank you.
And that's today's courtroom journey. Probation violations, land disputes, repeat DWIs, and even attorney drama. We saw defendants begging for second chances, prosecutors standing firm, and judges balancing caution with compassion. These cases remind us of one truth. Probation is fragile. One mistake, one violation, and freedom can vanish. If you found this case as shocking as we did, make sure to hit that like button, drop your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns every week.